This is CKnappenberger, and this is Module 12, Tort Law for EDL 850 in the fall of 2008. Tort law is essentially law where it protects other people from bad acts of people. When a person commits a tort, they violate civil law. Now, not all torts are crimes, although torts can be crimes, and it kind of depends on what type of tort it is. So there are two different types of torts, and there are intentional torts, and intentional torts can be crimes, assault or battery, inflicting emotional distress, or the thought of trying to commit emotional distress. These would be offenses committed by an individual, again, like they intend to do harm. Other torts are negligent torts. Negligence is usually a person doesn't act the way they're supposed to act or in a prudent manner, and therefore they've committed a tort of negligence by not doing what they should be doing. So in education, there are a couple of tort cases that I researched that I came across. The first one being Dollar versus Grammons. In Dollar versus Grammons, a middle school teacher decided that in their science class, he wanted to launch bottle rockets. So essentially they would launch the bottle rocket, and it would be made out of like a soda bottle, like a 2-liter soda bottle, and they would, with air pressure and water, they would kind of make the rocket launch. In the process of one of the experiments, the student's eye was damaged. So Dollar being the student, Grammons being the teacher. Judgment was made for the student and the student's parents originally, and the fact that the student's eye was damaged to actual full blindness, and therefore the court decided that the school district and the teacher needed to be liable for the damages. In the appeals court, the decision was actually reversed, and it was found that the teacher was not held responsible for the student's injuries and did not have to pay the damages that the parents had requested. In this case, it came up the idea of ministerial versus discretionary, meaning the school district sets forth a rule, and it's black and white, and it needs to be followed, and there's no kind of interpretation of it whatsoever, and it's very clearly laid out. And if they commit a ministerial kind of act, it means that they didn't follow the letter of the law. Discretionary comes into the fact that the teacher, there's interpretation in the rule or the board policy, and therefore there's kind of discretion when it comes to deciding what the teacher is going to do. What it was found is that the teacher in this case, it was discretionary in the fact that the law set forth or the rule set forth by the board there was room for interpretation, and the teacher interpreted it the best way that he could, and therefore he did not just deny his duties. He used his discretion in the experiment itself, which means that the students didn't wear eye protective wear during the experiment, which is part of what the parents brought up during the case itself. Looking at some of the things that my district might do as a reactive measure to this would reviewing all safety procedures in the classes, also purchasing safety glasses. It seemed in the readings of the case that sometimes safety equipment wasn't available to all students, or that the teacher would choose not to use them because they may not have it for everyone participating in the experiment itself. So again, some proactive measures kind of moving forward to avoid a tort like this. Make sure that all safety equipment is purchased before the school year begins, and also discuss with all the teachers in their classes what are their needs for safety, what kind of is in their curriculum that they're looking to do that requires certain safety equipment, so that things like this or the injury to the student's eye could be avoided. The next case is Hughes versus the Christina School District. In this case, there was a middle school student who was prone to fainting spells. And because she was prone to fainting spells, the mother came in and met with the school nurse. And the mother and the school nurse decided that when she felt like a fainting spell was coming on, she was to tell her teacher and say where she was, and that the nurse would come and retrieve her from that class in a wheelchair in order to avoid any further injury. In this case, the student felt the fainting spell coming on, but did not inform the teacher of it, or that she felt like she was going to have a fainting spell. She simply asked to go to the nurse. So the nurse sent her with a student escort to the nurse's office, but on the way she had a fainting spell and was hurt in the process. So the parents brought a suit against the district, the school nurse, and the teacher, saying that they were liable for the damages the daughter had suffered because they didn't act prudently. The court made judgment for the teacher, saying that the daughter was old enough to tell the teacher how she felt, or that she felt a fainting spell coming on, and that because she chose to withhold that information, that the school district couldn't be held liable for information that they didn't have. And so that therefore there was no settlement on the case of Hughes, and that the school district was found free of all kind of liability in this case. Kind of moving forward to just avoid the entire situation is reviewing 504 and IEP plans. Again, reactive measures. For similar accommodations, meet with the staff to discuss what the accommodation should be, also kind of what your policy is for sending students to the nurse and kind of what they're expecting moving forward. Some proactive measures, students like this or a student with a special case should just always be brought to the nurse in a wheelchair. Looking forward, if this was the agreement that was come to between the mother and the nurse, the teachers, all of the students' teachers should be made aware of this, and therefore anytime the student asks to go to the nurse, she should be going to the nurse by a wheelchair. Also, this should be documented in some type of 504 plan so that everyone is aware of the situation and therefore all the teachers are informed, and that situations like this wouldn't happen again. The next case would be Mitchell versus Cedar Rapids School Community District. In this case, there was a special education student. She was a low-functioning student. She was a freshman, a 14-year-old at the high school, and the teacher marked her absent, but didn't check with the office or with anywhere else, knowing that she had been there earlier in the day and then wasn't in her afternoon classes. The student had actually taken to cutting class with her boyfriend. She had called her mother and asked to go somewhere after school, and although the mother found it strange, it was the first request she had ever made, so the mother kind of allowed her to do that. And so the mother wasn't expecting her home right away. So when the teacher didn't inform the office or didn't inform anyway, the student didn't inform anyone of where she was going. The student was then raped off campus while she was cutting school with the friend. The friend ended up, it was her boyfriend, and the parents were not informed that the student was missing class or that the student hadn't been in her afternoon classes at all. And what the mother said is that they needed to be responsible for the fact that she had left campus. The sexual assault did take place in an off-campus building, not school affiliated whatsoever. It also occurred after school hours, but essentially what the mother in this case said was that had she been informed that the student had left school, she would have looked for her sooner, and therefore what happened to her would not have happened. Once the sexual assault was discovered, the district was then sued for the damages to the student. Court made judgment for the plaintiff in the sum of $500,000 for emotional distress and physical distress that the student suffered. Again, going to the idea that the school should have informed the mother earlier in this specific case, even though it wasn't school policy, they weren't acting prudently for that student. My evaluation of this is just reactionary, reviewing policies for attendance, checking with the director of special services, and again, reviewing all students' IEPs. What is it that is expected? Kind of what is the norm for students during the school day, and kind of going over with teachers what is expected of them. Some proactive measures is reviewing the attendance policy with staff. I know in my district, when a student is there in the morning and then missing in the afternoon, and I'm the first person marking them absent, I need to call the office in order to kind of check in to make sure that the student isn't hurt somewhere or that there isn't a problem somewhere else. Also, having an attendance office is very helpful. Small population of students or large population of students, kind of an attendance office helps take away that burden from teachers because there's someone constantly checking in on the attendance and where students are and where they've been or where they're going. The next case would be Munn versus Hotchkiss School. In this case, Munn was the student and she was bit by a tick while on a school-sponsored trip to China. The student was then infected with encephalitis and suffered damages because of being infected with this, meaning that she suffered mobility issues and she still suffers from cognitive issues. And although the student still seems to be an intelligent student, she does suffer from some cognitive delays in which the parents kind of sued for damages. based off of that disease, stating that the school didn't inform them of this and that they're held liable for the fact that she got bit. The jury made judgment for the plaintiff in the sum of $41.75 million, stating that although the school had handed out information about the location they were going to and warning students and families about the chance of this happening, being bit by these ticks, especially for the area in China they were going to, that's still kind of, the jury still made judgment for the plaintiff in this case. In my evaluation of this, some of the things that reactionary is postponing other school field trips, especially to that location. Also having a waiver on all future trips and kind of drafting up a waiver for the district. And what I mean by waiver is, again, proactively looking at something I could do or we could do as a district, is having a waiver system where parents are just kind of signing off that the teacher and the school district is not held liable if they were to be infected this way. They did provide the information from the CDC in this case, so kind of turning that into a waiver, saying that you have been informed of what could happen and that these are the proactive measures your student can take for it not to happen, and that if something does happen because your student doesn't take those proactive measures, then the teacher is not held liable. Also looking at just having parent chaperones moving forward. If they're worried about something like this, asking parents to chaperone rather than having staff members. The final case here is Sane versus Cedar Rapids School District. In this, Sane was a high school senior who was a talented basketball player and was looking to get a scholarship to a Division I school to play basketball. He did receive a Division I scholarship contingent on the fact that he finished all of his coursework in his senior year. He didn't like the English class he was taking in his senior year, so he requested his guidance counselor to switch him into another class that would satisfy the requirements for an English class. The guidance counselor put him in this class and said that the NCAA would accept it as fulfilling the English requirements. As it turns out, shortly after graduation, the student Sane was told by the NCAA, he was informed that the class did not meet the qualifications because it was not turned in for review from the school district itself. And because of this, it did not satisfy the requirements, so therefore he could not play basketball for the college he intended to go to, and then he lost his scholarship money because of it. He sued the district for negligent misrepresentation by the counselor and also for negligence in the counselor for failing to submit the course to the NCAA. Summary judgment was made for the school district, stating that the counselor could not be held liable for negligence based on academic course guidance, and that there was no actual physical damage or anything like that, and that they are not held liable for the course not even being turned into the NCAA. Some of the things is reviewing the courses that are offered, guidance, reactive measures, kind of reviewing what's there, what the NCAA didn't, and kind of changing and putting in for applications for courses to be approved afterwards. Also having guidance meet to decide on college counseling. There's meetings about it, who is best fit with each student. Moving forward, some proactive measures that could be taken so this tort could be avoided at least, is having college counselors familiar with student situations. Just having students who, perhaps if you do have a student athlete, having a part-time counselor that researches just those accommodations or looks into what is best for those students as student athletes. Also for any students, special education students who are looking for placements in college, and having, a special counselor meet with them so that everyone's needs are kind of met and that it's not just put on general counselors to be able to kind of fit into all these different areas. Looking at tort law and its effect on education and kind of what professional ethics has to do with that, proactive steps will reduce the risk of tort liability. Acting in a student's best interest, making sure students are always supervised, create environments where students feel safe. All of these things come from a professional code of ethics. And the stronger your ethics are, or the stronger that you kind of base yourself and your decisions on what's best for each and every student that you're dealing with, the risk for tort liability is lowered and reduced significantly. And also kind of that ethics where you're overcautious about making decisions. These is all things that will kind of avoid these torts altogether. Being best practices, kind of keeping your students safe, whether it's during an experiment or looking for them, when they are missing or you notice that they're not around. All of these things will kind of help to, again, reduce that tort liability. Thank you.